Good morning and welcome to our fifth Franczek PC webinar on K-12 coronavirus issues. We have our panel today that you've become used to, at least some of those members. We have Nicki Bazer.
Good afternoon, everyone.
Shelli Anderson.
Hi, everyone.
And Jennifer Smith.
Hello.
And we also have, again, by popular demand, we have a guest with us today, Ares Dalianis.
Glad to join you.
Just some quick housekeeping notes. So first of all, we are going to spend the first 30 minutes of today answering some questions that we received during the registration process and from clients over the past week. During that time, please feel free to submit questions through the Q&A link at the bottom of your page. Please use the Q&A function if possible. It allows us to track your questions, whereas if you send them through chat or raise your hand, we really don't have a way to easily respond to those. So if you could please put them in the Q&A, that would be great. And this will be recorded, so at the end of the session, you will receive a recorded copy that you can share with any friends or colleagues who were not able to join us. And so with that, let's two other quick things. First of all, Fattore Crumley is not with us today. She is dealing with a client matter, so she will be back to join us next week, we hope. And also, Ares does have to jump off for something else at 12:45. So if you see him disappear, that's the reason. All right, so let's jump in with our questions. So first of all, we got some really interesting, more general questions. One of them was, moving forward, what laws do you think will be created to combat or preface another global issue such as this? How do you think educational law will be impacted by this experience? Jen, do you have thoughts on that?
Yeah, so we're just starting to get some outlines of what people are thinking of, and I think what's coming out of California as far as the points on their reentry plan is interesting to think about. One of the points is that schools are able to, one of their points as a condition for reentry is that schools would have the capacity to support things like social distancing. And so there's discussions about staggered attendance, no large gatherings. It really makes your head explode to think of all the things you might have to do to actually support social distancing in a school. I mean, it really radically would redesign the way that schools are used, but it's interesting. Apparently that is something California is exploring, so definitely we'll keep monitoring that and see if that's an approach in Illinois. I don't think it's too soon to start thinking about, in your building, what would social distancing look like?
Yeah, that's such an interesting question. I know they're dealing with this in Europe too. I know Dana was just telling me the other day that Sweden is opening some of their rural schools, and they're doing sort of a staggered schedule. So some kids come certain days a week, other kids come another day a week. Obviously, that's a really complicated thing to do in the United States, in some of our districts in particular. We actually were on a call last night with some graduate students talking about this and how challenging it is because of the way facilities are set up in schools to do social distancing, in cafeterias, in multi-purpose rooms, in classrooms. And I think it's going to be a real challenge to start thinking through some of these issues. I know we're all still trying to catch our breath, trying to figure out remote learning, and then really looking to next school year to see how that's going to play out.
Sort of along the same lines, we had a question of, how do you foresee future educational laws adapting as the result of COVID-19, or future provisions for school closures in the event of act of God closures?
I mean, we continue to see advocacy for changes in the law. National School Board Association, I keep reporting, they did a call for action about a week ago seeking flexibility is kind of the key term for a lot of the school advocacy groups, seeking flexibility in the law to continue services and federal funding to support those changes. But I think to some degree, we just don't know the answer to this one yet.
So we, as usual, continue to get a lot of questions about ISB's guidance to schools. And one of them was, what weight do the remote learning recommendations issued by ISB on March 27th carry? Are districts required in any way to adhere to the student engagement durations given in the table on page 17 of that guidance? Nicki, do you have thoughts on that?
Sure, and I think we can look at this in a couple of different ways. So I'm just going to take one vantage point. You know, obviously with ISB guidance, it doesn't have the weight of statute or regulation, but we look to ISB guidance at this point to give us some parameters to work with. So I think they're useful to school districts to just get a general sense and some parameters on how to roll out remote learning. It also helps us think about, you know, obviously in terms of compliance for how these days are going to count as attendance days. You know, ISB is ultimately going to be reviewing school districts and their attendance and how this all fits together to count for a school year. And so to the extent that school districts can utilize those guidelines as a way to ensure that their days are, you know, following ISB guidance in terms of attendance days, I think that's going to be a great resource to do that.
I also think, I mean, Nicki, I don't know if you'd agree with this, but the way that they put out the guidance as, you know, liberally as they did to allow for different districts to meet those specific, and again, not requirements, but that guidance in a way that best fits their local district, really should allow everyone to not necessarily meet it exactly, but to come within enough of the parameters of it that everyone will be able to get those days counted the way that everyone's hoping to. I think was intentionally drawn that way to provide the most flexibility.
Yeah, I absolutely agree. And I think ISB has done a really nice job of acknowledging the equity issues and the issues of just, you know, we have such a wide variety of resources and capabilities and accessibility in terms of things like Wi-Fi and devices and just, you know, size of districts. I mean, across the state, we have a real continuum. And so I think the flexibility that they've put in there really allows for the fact that we're all experiencing this a little bit different and every school district is experiencing this a little bit differently.
So into the realm of student issues, we had a question of what supports are available to families who become homeless due to the COVID crisis. Any thoughts on that, Jen?
Sure. Well, the homeless laws, both state and federal, are not suspended at this time. So your homeless liaison should be reaching out with resources. Mainly for someone where residency isn't an issue, the support is through connection to resources, I'm going to say generically. And, you know, that person should work as an advocate to help those families to the extent they can. The other major issue that comes to play is residency. So as we finish this school year and move into the next school year, I do think residency could be a big issue as housing instability follows job loss. And where, you know, many of us might not yet know someone with COVID, I think unemployment has really hit nearly everyone, and this is an issue we're going to see.
Okay, into the employment realm. So what are the options if a teacher gets sick or has to take an unexpected leave? Shelli, do you have thoughts on that?
Sure. So I think there's two different ways you can answer this. One is I think I've talked about in the last few webinars, you know, in terms of how to handle if a teacher gets sick and how to document that and allow for that teacher to have benefit days, whether or not it's under the new emergency leave or under your regular collective bargaining agreement. That's one piece of or way you could answer the question. The other side obviously is what do you actually do in theory if you've got a class of students who are depending upon a teacher to engage in the remote learning and they're no longer available. And I think we've seen, you know, in one instance you have your subs that many of our districts still have on the payroll and working. So for them to be able to kind of slip in and do whatever engagement was required in that district's remote learning plan. The alternative obviously is to have another teacher of maybe that same grade take on the responsibilities of that class. And you have to imagine while it's remote, 50 kids is certainly different than 25 kids if you're responsible for that. So there's likely going to be some collective bargaining implications, whether it's the regular overload pay that you have in your contract or if you are going to bargain something separate as it relates to kind of this very strange, unique circumstance we find ourselves in. So I think those are the two ways we've seen it handled with districts we're working with.
All right, and rounding out our final category, special education. We got a question, any guidance about ESY planning with these questions in mind? Our ESY program is scheduled to take place in June. Staff have already applied. Parents have already begun to submit registration forms. Do I need to be considering a change of date to the program if the school closure extends into June, but schools could be open in July? How soon could we proactively plan for a remote learning ESY program? Jen, can you give us thoughts on that?
Sure. Unfortunately, I don't have the answer, obviously, on when we're going to be able to come back, and the range of, you know, speculation is pretty broad. I don't think it's too soon to think about a different way to do ESY. And again, looking at some of the states who are talking about return to school plans with social distancing, you know, think about that as you're planning. But, you know, is it time to just go fully, we're going to do a remote learning plan for ESY? I think we'll get more guidance from the state shortly. And I probably would wait for that before I started communicating to parents specifically that that's going to be the option. I think I would wait a little bit, but it's on everyone's mind. It seems very likely that that's the direction we'll end up.
Okay, and we're gonna keep rolling through some of these questions. I do wanna note that we've already got a lot of questions for Ares, and we are gonna bring him in a few minutes, and he's gonna give us an update, and then we'll get to those questions. But let's roll through a few more of our pre-registration questions before we get there. So on how should districts treat employee reports of having COVID-19 in context of possible workers' compensation claims? This is obviously a big issue right now. Shelli, can you give us some thoughts on this?
Well, first I want to say to all of our listeners out there who know me, you know that employment law is very different than workers' comp law, and I do not even pretend to practice that, but I will tell you that the answer I'm going to give you today is different than I would have given you a few days ago, because Illinois just did recently pass kind of a sweeping law that covers and presumes coverage for COVID-19 for essential workers who report having experienced it in the workplace for a workers' compensation claim. Now, what that actually means and whether or not it was intended to be as broadly written as it was with respect to not just our emergency frontline workers, but really anybody who's in an essential function. So that would include those folks that you have coming into your district to do your food service work or your secretaries. So right now, our guidance, our recommendation rather, is that if you have someone who is reporting to work, who does report to you that they have COVID-19, to make sure that you're filling out the appropriate workers' comp form and letting that process unfold just to make sure that you are in compliance with the new rules that recently came out on the 13th.
Okay, and then also, Nicki, we had a question about the impact of the COVID-19 crisis on Title I funding for schools and district eligibility. Can you tell us about that?
Sure, and I'm not sure I have a great answer at this point. I think a lot of these funding issues are unknown, and I know Ares is going to talk a little bit about state funding as well and what we're hearing. You know, in terms of Title I, obviously, as we talked about a little bit more last time, you know, under the CARES Act and under some of the federal stimulus money, Title I eligible districts or districts with Title I eligible students will be getting allocations. ISB has put out preliminary allocations. They're still awaiting the application process for that, and hopefully that will come through soon. So those schools with you know, a large percentage of students eligible for Title I funding will see some federal funding that way. In terms of an increase to the actual Title I funding, I think that's a real unknown at this point. I know there's been a lot of national calls for an increase given the impact that the closures have had on school districts that do serve a lot of students that are eligible. You know, we'll wait to see that. Obviously, we're hoping that the economic downturn that is predicted and are currently in effect due to COVID won't have a disparate, you know, proportional impact on Title I funding overall. But I think a lot of this is really unknown at this point.
Okay, Jennifer, what happens when a student does no work through this time at home and they get marked incomplete? Could they potentially get held back? How does it affect learning standards?
So no, in short, nothing is going to happen as far as they're going to progress to the next grade. And that's what the ISB guidance has been. So we know that students should not be adversely impacted by the work they don't do during this time period. Now, as far as planning and supporting needs and what that's going to look like in the fall when a student show up that haven't done anything since March, that's a different issue, but they will be matriculated to the next grade.
Now, we know everybody's working from home. We're all working from home. We've received some questions about should teachers expect reimbursement for things like Wi-Fi or data that is related to their expenses during remote learning. Shelli and Nicki, you got any thoughts for us on that one?
I think I'll start it. I mean, the Wage Payment Collection Act was amended in January of 2019 to require reimbursement for any necessary business expenses. And in this situation, because we do have, most of our teachers working remotely and electronically with our kids, we are likely to see some requests from either, teachers going to their unions individually or teachers coming to the administrators directly saying, is there going to be any reimbursement for the work that I'm doing because I have to have a greater data plan or I don't typically have that level of Wi-Fi in my house. And that's something I think districts are going to have to deal with individually and likely bargain whether or not and how much such reimbursement would be. Nicki, I don't know if you've had that question come up at all for you yet.
Yeah, not directly, but I think that that's right. And I also think we're going to see it beyond just teachers, because to the extent that, and I know we did get a question in that we'll probably address in a little bit about aides, but to the extent that your paraeducators are, participating in Zoom video conferencing or are calling home, we would expect to see that come up as an issue for those units as well, and you'll probably see requests coming in about that. I mean, I think the real, the real question I think beyond reimbursement is just, some of our rural districts, there's just not even Wi-Fi available and how they're coping with that. But I do think we're going to see some of those reimbursement requests coming in, and districts are going to have to think about strategies on how to work through those with their teachers and with their support staff.
And just one other point, I think that what our districts are already dealing with are when we have those aides at home, Nicki, that you were talking about, who may not actually have devices to be able to do the work or engage with kids we were expecting them to. Districts really looking, in their storage rooms and where they have other older devices that might be able to be, rehab, to allow those aides as well to communicate and engage with their other colleagues as well as with kids also. So I think we're seeing that as a piece as well.
Nicki, I wish I could say that we all felt that virtual board meeting issues have all been solved and running perfectly, but I know we still have a lot of questions. And one question we were asked was whether there's any update related to boards meeting virtually and the OMA.
Yeah, absolutely. And again, just to remind folks, what we're dealing with right now is trying to create openness and transparency given the shelter-in-place order. And so if you'll recall, the governor did suspend some provisions of the Open Meetings Act, specifically around allowing boards to meet remotely. The Attorney General's office, the PAC, as we refer to them, that enforces the Open Meetings Act, has come out with guidance supporting that executive order. We have seen now recently two PAC informal opinions, so non-binding opinions, confirming that, first of all, remote meetings for boards are acceptable, and also that taking, a lot of boards, particularly school boards, are taking public comment through email. So they're getting emails in, and the board president is reading those emails aloud. That process is acceptable. We also just had our First Circuit Court decision on this in a case that was brought against the city of Joliet. They sought a restraining order to prevent the city from hosting a remote meeting related to a particular annexation decision that the board was considering. And what the court basically said was, first of all, the challenge was that this meeting wasn't necessary and should be postponed. And the court said, it's up to the public body. They get to decide whether the meeting is necessary. And the second argument was that they hadn't made the meeting open and accessible. It wasn't reasonably accessible. And what the court said was, look, they posted notice 5 days in advance. They allowed people to comment through email and through telephone. It was streamed live on the city's website. It was on public access television. They recorded it and posted it afterwards. And that was certainly reasonably accessible. Those are definitely in line with some of the things that we're seeing our school district boards do. So again, public comment via email, streaming those meetings live on their websites, making recordings available. So again, we say this with the caveat that, the Open Meetings Act itself has not yet been amended. But this is the guidance that we have. And again, we have that one circuit court decision coming out.
Okay, so it's about 12:20 and we have a lot of questions for Ares, for our special guest. So I think we're going to switch over and give Ares an opportunity to, first of all, thank you so much again for joining us, Ares. And could you just give us a quick update on property tax, assessments, state revenue, transportation, whatever you've got for us?
Yeah, there's really 4 topics I wanted to address, Jackie. Thank you. And one is the timing of property tax payments, because that is something people are talking about. There's been a lot in the news lately on that. Expectations for assessments in 2020 and beyond, that's also been very top of mind. State revenue expectations, and then just a brief update on the transportation contract amendments, which many of you have been confronted with from your regular ed or special ed transportation providers. So with respect to the timing of tax payments, a couple things. One, so outside of Cook County, the due dates are June 1 and September 1. What we are seeing, what we have heard, and I'll start with DuPage County, is the county board met on this past Tuesday, the 14th. The county treasurer had prepared a memorandum and a draft ordinance for the county board suggesting a mechanism to delay for certain people the payment of those first and second installments. No action was taken. It's my understanding that action will be taken, although I don't know what the result is going to be. It seems like it's moving in the direction of passage at their April 28th meeting. What they will do, and this may catch fire and become an issue and something that other counties do as well, is invoke a provision of the property tax code. It's known as Section 2140. It really is for disasters. And if you go back and look at the legislative history, which we've done, the disasters that are contemplated are sort of typical Midwestern disasters, flooding and tornadoes. The provision's about 20 years old. It was sponsored by Judy Bart Topinka when she was a member of the General Assembly before she became a statewide office holder. And what that provision allows for is for taxpayers to come in and apply for relief if their property has been adversely affected or substantially impacted by the disaster. So what DuPage County is doing is they're grabbing onto the substantially impacted, adversely affected language, but applying it to the taxpayer rather than the property. So I think there is some question whether this might be sort of a square peg in a round hole situation. We'll have to see where that goes, but that is what's being contemplated here. And to their credit, it's a very targeted type of relief. If somebody is going to have a hard time paying their taxes, they would have to apply to the treasurer under this proposed remedy. And then the treasurer would make a determination whether or not they could have interest waived on the late payment. So statutory interest for late property tax payments is 1.5% a month or 18% a year. So what they're suggesting is that late interest could be deferred for a period of months. But keep in mind that a lot of people pay by escrow, and those escrows are just essentially injected by wire transfer into the county's coffers. In DuPage, historically, it's around 40%. In Cook, it's closer to 45%. I don't know the percentages elsewhere, but I'm assuming it's in that ballpark. So you're still looking at substantial compliance with tax payments. A lot of people are going to want to pay them just to pay them, so they don't have this potential liability hanging over their heads after June 1 or after September 1. And then in Cook, it's a little bit different. So the first installment's already been paid as of March 1. That was 55% of last year's taxes. There is the August 1st, second installment. So I have not heard any discussion of invoking 2140. I have talked to the Cook County Treasurer a couple times about this. I've talked to people in the assessor's office and in tax extension and at the Board of Review at the highest levels. And what I'm hearing is everybody is on track to do what they need to do in terms of close the books, certify the assessment, extend the taxes, print the bills, stuff the envelopes, get them out. So mechanically, we are on track for an August 1 second installment in Cook. Whether some intervening event occurs where the county board decides, hey, we like 2140 and we're going to do something like it looks like what DuPage County is doing. Kane and McHenry are talking about similar, although not identical measures with respect to the interest accrual. So it's really up in the air right now. And I guess I wouldn't be totally surprised if we see some delay on the second installment in Cook County by a month or two, or at least something where there would be no application of penalty interest at 1.5% a month. So that's really what's going on with the timing of tax payments. It's an unknown commodity, but it looks to be moving towards the direction of no interest on late payments, at least in DuPage and a few other counties. I want to talk about assessment expectations too, because a couple things. Outside of Cook County, 2019 was a quadrennial reassessment year. So as a general rule, you go to the township assessor, go to the board of review. In many cases, the assessment is set, taxpayer agrees that that is going to be their AV for the second, third, and fourth year of the quad. So you see no other appeals. 2020 is the second year of the quad outside of Cook. So we're looking at the possibility of more appeal activity in light of the impact of COVID-19. It's hard not to look around, and when you drive through your own communities, you see closed restaurants, hair salons closed, fitness centers closed, huge malls closed. So, open up the newspaper. Dick's Sporting Goods is not paying their rent. Cheesecake Factory is not paying their rent. Macy's has laid off tens of thousands of people. Penny's is not making its bond payments, so they're on the brink of bankruptcy. I think there's going to be some impact, certainly on retail, hospitality, food, and beverage this year. I think industrial, not so much. I mean, the backbone of the e-commerce system goes through these industrial warehouses for distribution and fulfillment. So that's 2020 outside of Cook. 2020 in Cook is a little different. So 2019, there was a reassessment in the north and northwest suburbs. 2020 is the expected reassessment in south and southwest suburban Cook. What Assessor Fritz Kagi announced just about 10 days ago, and we've done an alert on it, you can find it on our website, is that it's his intention to reassess all of Cook County this year. That would be an unprecedented undertaking. There's 1.75 million parcels. He's going to apply the same methodology for South Cook that he normally applies on a triennial reassessment. With respect to the city and the north and northwest suburbs, it's going to be slightly different. And I know that process is in motion, but it will not be a traditional triennial reassessment. It will likely be more the application of a factor to different categories of property that his data suggests have been adversely affected by the coronavirus. So we'll see about that. But I do expect, at least to the assessor and the board of review, in all parts of the state, there's going to be substantially more appeal activity. We'll see what happens in terms of how many of those migrate to PTAB or to the circuit court as valuation objections. Third topic that I think is of interest, and the governor's office released a new update yesterday from the Office of Management and Budget, is what the state revenue expectations are. So surprise, surprise, they are down from what everybody thought they were going to be early on. And it's interesting, if you look at his memo, the various categories that are down, it's really almost everything. Individual income taxes, corporate income taxes, sales tax expectations, inheritance tax expectations, insurance taxes, interest income, even lottery revenue is expected to be down. And then riverboat gaming, no surprise, those things are closed. There's 4 areas where revenue is expected to be steady or potentially up. Public utility taxes, not a huge component, but it's out there. Cigarette taxes, people are not going to quit smoking over the coronavirus. Liquor taxes, that's been steady because liquor stores are still available to sell their product. And then the cannabis tax, which is new for this year and next year. So it just seems that given what's happening with people's employment, with retail sales, with stores being closed, it's highly likely state revenues in most categories, and certainly the major categories, are going to be down significantly So when you sort of think that through a little bit, many of the funding sources, so let's take a look at, say, reimbursement of transportation expenses. ISB has communicated that they plan to reimburse these expenses even if the services are not provided, so long as it's subject to an agreement or some kind of an amendment. Now the question is, what's that reimbursement going to look like? How much reimbursement will there be? And is that something you can really count on if and when you enter into one of these amendments? So let's talk about the amendments. Nicki's worked on these, I've worked on these, Brian Crowley as well. A lot of our clients have been approached by their special ed and regular ed transportation companies to do amendments. We've seen them, we've seen our clients say no. We've seen a range of contract amounts between about 40 and 80%, covering various components of the bus company's costs. Many of these bus firms really immediately furloughed their workers and directed them to apply for unemployment. And that started for several of these firms starting March 17th, which was the effective date of the original executive order. So what we're seeing now is many of them coming back saying, hey, we need to maintain our bus fleets. We need to pay the rent on our location and wherever the location is. And so that's why you're starting to see some of these lower levels of reimbursement. But it is a company by company, school district by school district analysis. And we would just urge you to think about it from the perspective of what's best for your community and what do you think you're really going to get in the way of reimbursement. So those are the 4 topics I had. I did see a question come in on CPI. And so let me address that. And because I know people are wondering, hey, what is CPI going to be? Our last number, the December 2019, published earlier this year, was 2.3%. I went back and looked at the Department of Revenue's reported CPI going back to 1991. And so the last time we had sort of a severe shock to the American and the Illinois economy was the Great Recession, so 08, 9, and 10 really. And that's the last time we saw an extraordinarily low CPI factor. So the CPI for 2008, which was applied to your 09 levy, taxes collected in 2010, that was 0.1%. So really just a fraction, a hair above no reported inflation at all. So maybe that's where we're headed, you know, in terms of what we can expect for CPI. And I know the question's been out there, say, what happens if the CPI is actually below 0? What does that mean for the PTEL limiting rate calculation, et cetera? So I think that is somewhat of an uncertain situation, and I'll tell you why. The language of PTEL refers to, and I'm going to look down and read it, quote, the lesser of 5% or the percentage increase in the consumer price index. So we're not going to be anywhere near 5%, but it talks about the percentage increase. So let's say that percentage is 0 or that percentage is negative. What do? Does percentage increase really mean -2? Or does percentage increase mean if there is no percentage increase, it's 0? And I don't know the answer to that question. I think there are varying opinions on whether it becomes 0 or whether it's a negative number. I think that in that instance, we might see, you do have a big gap period between when it's reported and when you have to approve your levies. So it's possible that we might see some legislative action clarifying that language. But those are the 4 topics I wanted to discuss. I had scrolled through a few of the questions and certainly welcome to answer anything else, Jackie, you've got.
Yeah, great. So I guess one of the first questions, or it's one of the last questions, but is the escrow figure of 45%, does that relate to all property or just residential?
No, that is across the board. So when I was talking to the Cook County Treasurer and her Deputy Chief of Staff in a different conversation, there are 1,750,000 parcels in Cook County. 780,000 pay via escrow. My guess would be that would largely be residential, because many folks, when you take out your mortgage, one of the things they strongly ask you to do is escrow your taxes so you're not confronted with a big bill twice a year. And it's probably mostly escrowed, although I'm guessing there are probably a small component of commercial and industrial in that as well.
And then for those PTEL districts, we have the question, can a negative CPI take a public body's extended abated number for this year below last year's?
Well, I think, you know, it depends on how you answer the question that I raised, which is what does the lesser of 5% or the percentage increase in the CPI mean? Does it mean it could be a negative number. And I think if the answer is yes, it could be negative, then you could have an aggregate extension lower this year than you had last year. If it really means 0 is the default, then it would be flat. Keep in mind, we still have that 3-year rollback provision, or look back, I should call it, where if your extension is lower than a prior year, in the next extension, you can look back 3 years. So if 2 years back or 3 years back, the extension is higher, that's your base number for purposes of the next year.
So we had the question if you could talk through a worst case scenario of how property tax revenue could be negatively affected by a severe downturn in the economy.
That's a good question. I mean, how bad do you want it to be, I guess would be my question. I would say that it is, likely. Let's start with Cook County, where the assessor's doing a total reassessment based on what has been reported. I think it's highly probable that a lot of properties are going to get a factor applied to them, reducing their assessment. So if it's the north and northwest suburbs, and you're talking about Evanston Township, Wheeling, Elk Grove, Schaumburg, Palatine, all of those townships in the aggregate saw big increases in AV. We don't know the EAV yet, but generally the AV is significantly higher in 19, which was a reassessment year in that part of the triad. So if the assessor applies significant factors to certain residential classes, certain retail, commercial, that's going to undo a lot of the increase that these districts are picking up in 19. So you're talking about a lower EAV, and obviously what we don't know is what the state factor is going to be. And keeping in mind, what is the purpose of the equalization factor? It's to get Cook to 33 1/3 of fair cash value, similar to the other 101 counties in Illinois. So it's really hard to say, but if this thing continues and the assessor applies significant factors reducing assessments in 2020 in the city of Chicago, in the north and northwest suburbs, and as part of the triennial reassessment in the Southlands, you could see a big drop in EAV below where it was in 19. Outside of Cook, I have not heard of any across-the-board reassessment process that is being contemplated, but you could very well see significant appeal volume that could effectively yield a reduction in the EAV below the 19 number. I think that's really unlikely, but I think it also depends on how long this thing plays out.
So we also had the question, considering how we all expect tax collections to be hit fairly hard this year, what is the best way to find information about collection percentages?
Yeah, so you should know from the distribution reports that you get from the county treasurer what your percentage collection is every year. And obviously you know the historical numbers. So as the revenue starts to come in, especially as you get past June 1, past August 1, and past September 1, you will see that your numbers are a lot lower than they were last year or 2 years ago or 5 years ago. What I've seen a lot of clients do is when they see that sort of abnormally low collection percentage, they start looking at some of the larger properties within their jurisdiction to see if maybe there's one taxpayer that hasn't paid. Maybe they're in bankruptcy and they need the stay to be lifted in order to pay those taxes. Maybe it's a bunch of small taxpayers, but there are ways to make that inquiry so you can at least make a determination, hey, it's really just the shopping mall that didn't pay, that's why we're down, or there's widespread non-payment within my community for a variety of economic reasons, job loss, industries disappearing, things like that.
Okay, and then do you envision CPPRT school district allocations to be rated to pay for other expenses in the state, or would this further strain the EBF formula?
I don't know, honestly. I think you have to look at all state revenue being down. So that's sort of our baseline assumption. If every source of state revenue that is meaningful, putting aside cannabis and cigarettes, is down, you have to assume there's less money to spend in every other category, which would suggest to me the replacement tax is going to be down too. And then with respect to EBF, what I have been hearing is, certainly tier 3 and tier 4 districts should not count on everything that they are thinking about getting. It could be greatly reduced. It could be zero. And I've heard one scenario based on an interpretation of the statute where Tier 3 and Tier 4 would actually have to pay back into the system the dollars they've received over the last 2 years. So I think that strikes me as sort of a worst case, very dire situation, but it's certainly a possibility. And then the other wild card we have, we had the first, the CARES Act, which was, $2.2 trillion in the aggregate, $30.75 billion for education, a little less than half of that for the K-12 world. The federal government is not done with its stimulus programs. More money will be injected into the system. So the question becomes, if you need $350 million for the EBF, how does that fit into another trillion or two of federal dollars being spread across the US economy generally? So, the printing presses are running when it comes to dollars being pushed out into the economy. How far does the federal government go in terms of reaching into state government finances to make whole or make good on certain promises? And I think EBF is in that category.
So we had another question during the registration process that kind of fits with this discussion. So in light of the closures, do we anticipate less money in evidence-based funding, and will the stimulus money cause a reduction in funding from federal sources? Nicki and Ares, do you have thoughts on that?
Nicki, go ahead.
Yeah, I would just echo what Ares said. There's a lot of unknowns here at this point. Because revenue is likely to be down, is projected to be down in the state, we do anticipate less money going into evidence-based funding. But again, as Ares pointed out, if there is federal stimulus money or the other federal funds that come that can be used in that regard, that may offset. There's a lot of unknowns in terms of what's going to come both at the state level, but also particularly from the federal government.
I've got nothing to add to that.
Well, Ares, I know that
Jackie,
you got, yeah.
Jackie, if we're on the topic of federal money, should, just a question for Ares and Nicki. So the small business loans, when we're talking about these contractors and the transportation agreements, as we start to hear about some small businesses getting those loans, should we consider that when renegotiating those amendments?
Absolutely, Jennifer. Great question. So what Jennifer's referring to is, as part of the stimulus package, $350 billion was set aside for Small Business Administration, SBA loans. Now, interestingly, that program was exhausted effective this morning based on an email I got from the Wall Street Journal and maybe other publications too. But a lot of, say, the bus companies and the food service companies, they are likely applying for some of the programs here, like this payroll protection program, PPP, where for firms that are under 500 people, there are certain benefits that are available. You should be mindful of that, and your agreement with your, say, bus company should contemplate, at least think it through, that there would be reimbursement to you for a payment if you're covering their employment expenses and they're also getting those employment expenses covered through the SBA PPP program. There shouldn't be a double payment. So you need to have a provision in there to be reimbursed in that event.
Yeah, and Jen, the folks that are looking at the amendment that we prepared, that is contemplated in that amendment, as well as the unknown of state reimbursement. Obviously, the state has come out with both emergency rules and FAQ guidance on the reimbursement of transportation expenses. But as Ares alluded to earlier, and as we've discussed before, even if districts are potentially eligible for reimbursement for transportation expenses, those are dependent on the EAV and the size of the claim. And, so how much districts are actually reimbursed is an unknown. So any amendment that you are, contemplating with the bus company, as Ares said, should accommodate all possible sources of funding and reflect what you're going to do depending on where those monies come from.
Yes.
So one final question for you, Ares. Any insight into whether or not property tax relief grant funding will be distributed to districts who have had completed the required abatement?
Well, that is a commitment that's been made. So again, it sort of goes back to if there's less state money available, will these payments be made, Jackie? And I don't know. I think if this thing resolves itself with the executive order, say ending on April 30th, or even being extended by another, New York just extended out to, Governor Cuomo extended out to May 15th, his stay-at-home order in New York State. So let's say Governor Pritzker does something similar to that, or even the end of May. I think America will get past this. But if this is really a hunker down situation where perhaps school does not resume in the fall, kids are not going back to their colleges and universities, I just don't see that relief grant payment being a high priority for anybody if we're at that point.
Well, I know we brought you right up to the time where you need to leave us. Ares, I have to say, this is one of the things I love the most about being at Franczek is being down the hall from, or I guess in this case, being down the Brady Bunch box from you, and all of the other great attorneys with their expertise. So thank you so much for sharing it with us all today.
Well, thank you for including me. This was my pleasure. Let's do it again, guys. Take care now. Thank you.
Absolutely, and we'll keep answering. We've got a lot of questions from folks on a myriad of other topics, so we can move right into the live questions we've received. So Shelli, I've got one here for you. What advice can you give for districts in the middle or end of negotiations with potential multi-year contracts?
Well, I think this question came up during our last webinar as well. And I think that, as many of us are out there trying to assess where we're at with contracts, I think whether you're in the beginning, the middle, or the end, I think having a really transparent conversation with the union team about the board's hesitation to enter into anything beyond a one-year contract at this point. I think all of the contracts that I'm working on are either looking to just be a 1 year with some language changes, or just a 1 year rollover extension with limited changes, just to see where we're at next year. So I think that the advice would be to just really, same as I said last week, to have as open a conversation with your union folks as you can about the board's hesitancy to really do anything beyond 1 year, and that it's probably in their best interest that we not force the board's hand to try to determine what finances will look like beyond next year, what CPI is going to look like, and we don't know any of that right now. So I think many boards are saying kind of make it a 1 year contract and then we'll reassess and see where we're at. So that would be my general advice. And I would say even if you've already determined duration and you did that, back months ago, I would still reach out and seek some room for discussion and further negotiation with the union team on that, because the world just is a different place than it was back in early March. So
that makes a lot of sense. All right, Jennifer, we have a question. It may seem ridiculous, but maybe give a second or two to the president's actual powers over local school districts. Can he declare schools back open?
Sure. So kind of a fun question to think about when you think about federalism and who's the boss, so to speak, of schools, who gets to make decisions for schools. Most of the federal authority over schools has to do with funding. So what I could contemplate is some arguments being made that certain laws, the strings attached to funding would include being open in some way, some interpretation along those lines. That is, if I were to try to come up with an argument in favor of, federal control, it would be that your funding would be tied in some way, or maybe new funding. As they come up with new funding, you have to open in order to get access to some new pot of money. I could contemplate that. The reality is, I addressed this a few webinars ago, the state, as far as having access to our physical buildings, the law in Illinois is clear as far as the emergency law that the governor has that authority to limit access to our buildings or limit the number of people that can be together. So that is definite. And if we have a conflict between those two, I think you've heard, constitutional crisis thrown out. We just have to see how that plays out. But I think those are the principles that I would be looking at, and to see what authority is being flexed.
All right, Nicki, I've got a question for you. As an educational advocate, I've heard from parents that are spending significantly more than the recommended amount of daily time on remote learning work and still being unable to complete all of the work being sent home. They're concerned about their student receiving an incomplete designation and what the implications of that may be. What recommendations would you have for parents in these sorts of situations, or I guess even for schools in helping to mitigate this type of anxiety?
Yeah, and I think we addressed it briefly before about the unlikely scenario that students would be held back in any way. We don't see that as a possibility at this point. I think that this is a really great question because I think we're all experiencing this either as educators or parents or as both. I do think that if parents are experiencing sort of significant amounts of work and it's really becoming unmanageable, I would have them reach out to their teachers, their children's teachers, certainly if they're not getting a response, the principal. I know that school districts, having worked with so many over the past month on these issues, are really feeling for their families, for parents at home trying to manage this, for their teachers, and wanting to be flexible, wanting to make sure that students are experiencing remote learning in a way that they can deal with emotionally, and that they have the time and the space to do other things as well. So I would really encourage open dialogue. I would definitely encourage our educators on the call if you feel that a student or parents are struggling, to make sure that you're reaching out, that you're making this manageable. I don't foresee districts handing out incompletes to students at this point. We're sort of in the do the best that you can kind of scenarios with schools, and I think that's how most districts are approaching it. But again, those open lines of communication are so crucial. Even if we're remote, get on the phone, express those concerns.
Absolutely. That's the advice I've been giving to even my own friends who are, dealing with these types of situations. Jennifer, will schools be potentially exposed to civil suits as a result of the digital divide? So not being in position to deliver services in an equitable manner given differences in access?
So that's a really interesting question. We as a firm have represented schools who face these challenges on issues like facilities. So for example, there's litigation about portables, who gets assigned to portables. There's been litigation about who gets certain programs and access to those. So I'm thinking through those types of that type of litigation, and I certainly think it's possible. I mean, I think it's similar. It would be very similar. So sure, but you want to look at what are you doing systemically? Are you purpose or kind of institutionally depriving a population from education in the way that you've designed this? That is certainly what we want to avoid. So there should be thoughtfulness to how you're supporting different populations, and yes, one consequence could be litigation and even liability possibly.
Shelli, we got to follow up on employee questions. When we come back, if we have staff who aren't comfortable coming back, should we have something in place that states they need to use PTO?
Well, that's a great question, and one that I don't think that we can fully answer, because you've got to hope that when we are permitted to go back to our regular life, and that includes teachers and staff going back to school, the four of us going back to our firm, that it'll be done in a way that we can all feel confident that it is a safe place to be, whether or not it's because we can all be together as we were before or with social distancing. So I have to say that as a caveat, that I'm struggling to imagine a world where we aren't all going to be at least somewhat comfortable by the time they let us go back to work. And that our governor's done a great job, I think, of being really careful about that. To the extent that you've got someone, however, who is still for a particular reason concerned about coming back for whatever reason they may have, I think that we have so many great HR professionals out there to really sit down and talk to them and figure out what's going on and why they don't want to come back and where the fear is coming from, and then assess what benefit options are available for them at that point. I don't see the need to be looking now to create kind of a new bank of PTO days or something like that to accommodate this. Because again, I can't imagine a scenario where we're permitted to go back where we are all collectively as a society feeling safe doing so.
Jennifer, we received two questions that seem to go a little well together. So one is about the obligations to provide homebound instruction, and the other is about the obligation to test students whose parents are requesting evaluations for special education services. Could you give us a quick reminder on what the current understanding of those responsibilities is?
Sure. I've taken the position so far that homebound can be accomplished at this point through most remote learning plans. And really the difference between a homebound teacher versus the student's classroom teacher providing remote support, because a homebound teacher is not going to actually be going into the home now. So to me, the same support can be provided without actually assigning a new specific teacher. So I would accept that homebound and say we're meeting that. So people have to provide a medical certification. So you get the medical certification, and then you meet that need still through your remote learning plan at this point. Now it'll be relevant if school resumes. On the evaluation question, we're now within 60 days of the end of the school year. So one, I do think you need to timely respond, and how you respond, whether you agree to do it, is going to depend on the situation of the individual student. But as far as timing, even if you agree that a case study is warranted, and I do think one of the circumstances you're considering is that we're in remote learning and whether it makes sense to do an evaluation at this point. But if you decide it does, because of the point we are in the school year with the number of days remaining, it wouldn't be due until the first day of the next school year. So we're already into the part of the year where there's a longer time frame. Summer evaluations are tricky in the best of circumstances, but that would be the general things you'd think about.
Shelli and Jennifer, I know you guys have been working on the evaluation question a lot as far as proficient versus excellent. So we had a question of, can you provide some clarification to the proficient default as stated in the joint agreement and the recommendations if a district is interested in considering an excellent default, if a teacher did not have noted deficiencies, or if the evaluator would not have rated the teacher as excellent?
Okay, so I guess I'll start this. And I will say that, we acknowledge that there are two places in the school code that talk about a default to proficient. It's one with respect to whether or not a teacher is attaining tenure, and the other is for purposes of the sequence of honorable dismissal list. And what the language talks about is that if a evaluation has not been completed in a school year in which it was supposed to be, it defaults to proficient. And I think that as a general principle, our recommendation is that that makes sense for those teachers who have not had their evaluations completed. But I do want to say that we've received, calls from many of our clients who, for very good reason, have some outstanding teachers who received excellent evaluations 2 years ago. And remember, we are talking about tenured staff. Virtually every client I work with, and I think the three of us, all of us work with, have already taken care of their probationary teachers' evaluations because of when the non-renewals have to go out. So to the extent we're talking about tenured staff who 2 years ago received an excellent rating, and that at this point, let's say there's been the one formal observation done, but we haven't kind of completed all those different other pieces. Maybe the informal wasn't done yet, and those are the two pieces that are required under the school code or in the regulations. And they have no noted deficiencies, and we know that for the last 2 years they've still been the superstar teacher who would otherwise get an excellent rating. I can completely understand why we would not want that probationary teacher who received the excellent rating because we happen to get them done earlier, being rated higher than our long-term tenured teacher. So in those circumstances, we have talked to districts about how we can work with the union, either on a default under certain circumstances to a different rating than proficient, so to an excellent rating. And quite frankly, if you're working with the union, there are also creative things you can do with your evaluation plan itself. So for instance, right now, many districts, of course, do not want to have their teachers evaluated during remote learning. But what's to say you can't? If you have a teacher who's doing phenomenally and the only piece left is that observation piece, it's likely everyone's going to agree that that can be done remote learning. Then you have your summative conference, and then that evaluation for purposes of the school code is complete. And it's not even a matter of a default. So I do think there's creative ways to get around this. We don't want to be We don't be harming kids, and we don't want to be harming our teachers just because they are out of school right now and we were otherwise following a typical timeline that we were following. So, I mean, I think talk to for those of you out here that have the question, talk to the attorneys that you typically work with. You know, I'm happy to have a conversation with you. I know we all have different views on it, but I do think this is, if nothing else, the time to be creative and work together in every aspect of kind of the school world. So.
Yeah, I guess the only thing I would add is it probably brings up an issue that we're talking about, a lot of issues where there's going to be variations when you look at risks, impacts, your school culture. Different districts are going to make different calls on what works for them. And this is one of those issues where we've seen some variation, but there's others. I mean, there's a new playbook, so to speak, and many of these issues are being contemplated, and so I don't think it's a bad thing that districts consider their own needs in making these decisions.
So we're almost out of time. Nicki, there was one question of, was there a sample agreement shared for language to discuss with our contracted staff, like transportation or food service? Any answer to that?
Sure, we did not share it generally, but if you are interested in negotiating something with your bus company or your food service in terms of payment to employees while this is ongoing, either for different services or no services, feel free to reach out to me. You can reach out to Ares if you work with him. If you work with Brian Crowley, you can reach out to him. Any one of us can work through. We have a couple of different variations depending on what you're looking to do with your company and what the negotiation is. So again, happy to work with you on that if that's something that you need.
All right, thank you so much.
Jackie, you're muted.
Thank you so much to everyone, and thank you to our panelists and our audience members. We really appreciate you joining us and for all of the engaging questions. Please remember to check out our website. We actually started a new COVID-19 resource center this week on our website that will allow you to very quickly locate alerts and other material that we've published based on the topic. So please check that out. If you have any questions that you would like us to answer next week, please send us an email at allmarketing@franczek.com. And otherwise, we hope you have a great weekend, and we'll see you all again next week. Thanks, everyone.
Bye.